Good afternoon, everyone. Welcome to the Judicial Proceedings Committee. Today is Wednesday, March 25th, 2026. We are on our first set of House hearings, and we have 10 bills on the docket. We're going to start off with Delegate Smith with House Bill 536. Delegate Smith, welcome.
Thank you, Mr. Chair and Mr. Vice Chair and distinguished members of JPR. I'm here on the record, Delegate Stephanie Smith, here to present House Bill 536. This is actually a very, very simple bill. It expands the temporary disability article, most commonly referred to as the pregnancy article, to be inclusive of temporary disabilities that are tied to childbirth, as well as symptoms related to menopause and perimenopause. There was one floor amendment brought by the minority that we accepted as a friendly amendment. It largely codifies the implied parts of the statute around if accommodating an employee does pose an undue burden to that employer, then they do have opportunity to appeal. And so we think that was a reasonable common sense amendment that I know there's some concern from the Maryland Commission on Civil Rights about it being duplicative, but if this was something that made our chamber feel confident in supporting it, and it ended up being a bipartisan supported bill, we think it's beyond time for women, whether they're giving birth to children or not. If they live long enough to experience perimenopause and menopause and they need those workplace accommodations, it seems only reasonable that we keep people productive and working and paying taxes as long as possible. So it's with enthusiasm as well as deference to the brain trust before me that I enthusiastically present House Bill 536 and do wish and hope for a favorable report, and happy to take any questions.
Excellent. Questions from the committee. I see Senator Sidnor has a question.
Yes.
Thank you, and good afternoon. Where in the bill is this amendment that was put on?
It was a floor amendment that should be in the reprint.
Right. Where in the bill?
Page 3. I apologize. I didn't have it.
Page 3?
Yeah.
Which line? Number 2?
Yes.
Thank you very much.
Okay. Happy to take any other questions.
No questions? All right. Excellent.
Okay.
Thank you for the fantastic bill. Thank you for the bill.
Thank you so much. There is no cross file, so I am at your mercy. Thank you so much.
Excellent.
Thank you.
Well, you have one witness signed up
sure.
also in favor, but that witness has informed us they can't make it right now, so that this runs a little bit of trouble here. So we have one person signed up virtually who is in opposition, and let's hear Laura Bogley. You're up. Welcome.
Good afternoon, Mr. Chairman, members of the committee. I'm Laura Bogley, Executive Director of Maryland Right to Life, and we urge your amendment of or unfavorable report on this bill. Maryland Right to Life supports any sincere measure to empower women to choose life for their children, but we will not support this bill, which would require employers to accommodate and bear the expense of elective abortions for employees. State and federal law already protect women against employment discrimination for pregnancy and pregnancy-related conditions, but this bill is an attempt to undermine post-Roe federal law and judicial precedent, including the recent federal court ruling in Louisiana and Mississippi versus EEOC that struck down the Biden EEOC's misinterpretation of the ill-conceived Federal Pregnant Workers Act, which was hijacked by abortion activists despite legislative intent that specifically excluded elective abortion. The state of Maryland is already under investigation by the U.S. Department of Health and Human Services for policies that force insurance plans to provide or pay for elective abortions against their conscience. This bill does not include a conscience clause to ensure the rights of employers. The consequence of enacting this bill will be more lawfare and costly litigation borne by state taxpayers. To be clear, there is no federal restriction on covering the costs for medical treatment for legitimate pregnancy complications like miscarriage, and employer health plans already cover this expense. But intentionally ending the life of a living human child through abortion is never medically necessary. For these reasons, we seek your amendment to exclude elective abortion mandates or urge your unfavorable report. Thank you.
All right, thank you very much. Questions from the committee for the witness signed up in opposition? It's up to you. All right. All right, seeing none, thank you very much. With that, that'll conclude the hearing for House Bill 536. Thank you very much, Delegate Smith. All right, we're now going to move on to House Bill 53 with Delegate Lehman. Is she here?
Thank you, Mr. Chairman. I have a panel with me. You're the only. Okay. So thank you, Mr. Chair. I have one in-person witness and
Sure, we have a couple other witnesses signed up. Is that your panel? Do you have anyone else, Ms. Radoff, signed up? She's virtual. In-person, Kimberly Fullerton. Stacy.
So good afternoon, Chair Smith
Or that.
and members of the Judicial Proceedings Committee. For the
Delegate Lehman,
record,
can
I'm
you-
Delegate Mary
Delegate-
Lehman.
Sorry, can you hear
sorry.
us? I'm sorry, can you hear me? Can you hear me?
Yes.
Okay, great. All right, excellent. There are a couple of other folks that were signed up on your panel. Did you want them to join you as well?
Kimberly Fullerton from the Maryland State Bar Association is not able to make it
Okay.
at last moment.
Excellent.
Yeah, I'm sorry, my witness list changed right up to the
No
last
worries.
minute.
All right.
I apologize. Are you ready? Yeah, go, okay, thank you, Mr. Chair. So good afternoon, Chair Smith and esteemed members of the Judicial Proceedings Committee. For the record, I'm Delegate Mary Lehman, presenting House Bill 53. House Bill 53 proposes a focused, necessary update to Maryland's existing law prohibiting the trade, breeding, or possession of specific wild animals, but it includes common sense exceptions. So the goal of the legislation is to strengthen public safety, relieve burdens on local law enforcement and animal management staff, and ensure humane treatment of wild animals. Maryland law currently prohibits the trade, breeding, and possession of many inherently dangerous species, including bears, non-human primates, wild cats, and certain venomous snakes, with exceptions for certain licensed facilities. It has been more than a decade since this statute has been updated. HB 53 builds on the well-established foundation by adding zebras, kangaroos, wallabies, and wallaroos to the list. These are species whose recent escapes and injury records make clear that they pose significant risks when kept by private individuals. HB 53 also repeals an outdated exemption for certain so-called helper animals without affecting legitimate service animals. So comparable to buying shoes or electronics, our policy research showed that animals can be purchased and shipped online as objects rather than as living things. An intern of mine researched how many websites provide less information about the animal, seller credentials, or legal requirements than is typical for consumer products, relying on undisclosed third-party breeders who do not verify purchaser qualifications or comply with state laws. These vendors regularly ship directly to Maryland, shifting all legal risks to buyers. The House hearing bill file includes written testimony naming several of these sites, highlighting how unregulated and accessible this market actually is. So in terms of public safety concerns are neither hypothetical nor rare. In 2021, multiple zebras escaped from a USDA-licensed breeding facility in southern Prince George's County, and those zebras roamed residential neighborhoods for months, triggering a multi-agency response that you will hear more about from a former Prince George's County agency head. Similar problems have actually occurred nationwide and involve other species as well. Kangaroos, wallabies, and wallaroos have escaped at least 83 times. That's 83 times that are documented across 25 states, and that is since 2015. Just last month, an adult kangaroo in Nelson County, Virginia, outside Charlottesville, was spooked by hunting dogs that got into its enclosure. That kangaroo leaped an 8-foot fence and ran miles out to busy U.S. Route 29, where it miraculously was was not hit by a car, but it created, as you can imagine, a major traffic problem. Sheriff's deputies managed to coax it out of a travel lane, and the owner came and subdued it with a tranquilizer gun. Adult male kangaroos can reach up to 200 pounds and be well over 6 feet tall. They can inflict serious injuries. These incidents strain animal control, law enforcement, and medical response resources, and highlight that private individuals cannot safely contain these wild animals. So the bill also repeals an outdated exemption for certain so-called helper animals. It removes one narrow and outdated exemption that historically allowed certain wild animals, primarily non-human primates, to be used as so-called helper animals. The exemption is inconsistent with the Americans with Disabilities Act, which since 2010 recognizes that only dogs and in very limited cases miniature horses are effective as service animals. The American Veterinary Medical Association, which opposes the use of primates as assistance animals due to the high risk of human injury, disease transmission, and animal welfare concerns, and modern disability access standards that emphasize safer and more effective alternatives such as assistive technology. All Maryland service animal statutes will remain intact under this bill. It does not alter, limit, or affect any of Maryland's existing service animal programs or protections. All protections under Title 7, 9, and 10 remain fully in place, including the state's service animal program, the veteran service animal program, court dog program, and laws safeguarding service animals from harm or interference. This legislation updates wild animal possession rules without altering any rights or accommodations for people who rely on legitimate service animals. I do have an amendment in the works, Mr. Chair, and I am collaborating with the Maryland Department of Agriculture on that. It is an attempt to address what we consider unique and exceptional ownership circumstances of some of these species. So in concluding, by adding zebras, kangaroos, wallabies, and wallaroos to Maryland's existing wild animal restrictions, HB 53 ensures these species are kept only by licensed facilities subject to the requirements of the Federal Animal Welfare Act. HB 53 strengthens public safety, reduces avoidable burdens on law enforcement, promotes responsible stewardship, and ensures Maryland law keeps pace with modern science and service animal standards. The bill is measured, I believe, and builds on the General Assembly's approach to protecting communities from very risky wild animals. For these reasons, I respectfully ask for this committee's favorable report. Thank you.
Good afternoon, Chair, Vice Chair, and esteemed committee. My name is Stacy Volodin. I'm the Maryland State Director of Humane World for Animals, formerly known as Humane Society of the United States. I am here to urge a favorable report on HB 53. I don't want to belabor many of the sponsors' points, but I'm going to skip to a couple of important subjects. This is a simple add-on to already existing framework. We already have it in the law: bears, large cats, venomous snakes. We are simply adding kangaroos and macropods. Zebras and macropods, the kangaroos, wallabies, and wallaroos. That's as complicated as this bill truly is, with the generous exceptions that were already laid foundationally with the original bill. There are generous exceptions for licensed facilities from whom we believe that there's a good faith misunderstanding of this bill. They are exempt from this as long as they are a good standing USDA licensee. In addition to that, we're trying to be clear that the purpose of this bill is not to affect businesses whatsoever. It is simply to prohibit private ownership of extremely dangerous and documented animals by unqualified individuals in places where these animals do not belong, like your suburbs. I can say confidently that within a 15-mile radius of where we are sitting right now, one of these animals exists, and I don't think that anyone is necessarily comfortable with having these animals as a next-door neighbor. Private possession and breeding of these wild animals is not conservation. I do also want to highlight that point. Genuine conservation is aimed at species recovery in the wild on their own home territory. Kangaroos, Australia, zebras, the African savannas. When breeding is used for conservation purposes, it's done through coordinated and scientifically based programs. For these reasons, we urge a favorable report. Thank you.
Thank you very much. All right, we'll take questions from the committee before we switch to our virtual panel. Senator James, then Senator Waltrecker, then.
I've known Stacy for, 30? Yeah, and she's wonderful, and so I'm glad that you are collaborating on this bill, and I just happened to finish watching, I wasn't going to watch it, I think it's called Tiger King, a Netflix series, which just blew my mind that people are, bring in these cats and then breed them, and then whether it's legal or not in the state, they do it with abandon and sell them all over the place. So, I applaud you all for bringing this to our attention. It's very hard to keep up with this issue, and I'm sympathetic to people that love these animals, especially when they're little, and then don't fully appreciate what happens when they get larger. But here's just my general question about, first of all, I'm surprised we need it, because I figured if we've already made it so you can't have lions, tigers, and bears, I kind of didn't think we would have these other animals, although you do make a point that they're dangerous even if they don't appear to be initially, like a zebra is not a horse. I love horses, but do you think this is a growing problem in the United States? And if so, what is making it easier? Because I don't understand how easy it is to import African animals, as amazing as they are, and get them at your house, and and I don't even know how they get in this country, and then why is it a growing problem? Because you would think it would be getting harder, not easier.
Absolutely. Thank you so much for this question. It's great. So I can't speak to why people truly want these animals, but what we have seen, I can speak to patterns that we have seen. So since about the time of COVID, we have seen essentially, particularly with these animals, these covered species in this bill, their growth in popularity increase. And whether social media has an influence on that, I would personally, I don't have the data on that, believe that to be the case. But what I can say is that we see there's a very strong correlation between the interactive exhibits that you go to at your local USDA Class C exhibitors where they interact with animals, and then and they think these are lovely animals to interact with, why don't we bring one home? And the private possession starts to grow. What I can say within Maryland is that a decade ago, there were 2 kangaroo within the state at USDA Class C licensed facilities.
Oh, I see.
Now there are 34 in such facilities, so if those correlations continue, the pattern, as expected, would be that the private ownership continues. Now that's in particular with the kangaroos and the macropods, the wallabies and wallaroos.
I know. So, but how do they get into the country? Do you think they come in through a sort of an okay channel, and then once they get in the animals, somebody then steals them and breeds them, or what, how are they getting into this country? It drives me crazy that stink bugs got it, but I kind of understand how they snuck in along with those lantern things. But these animals, other than I know that you can sneak some steaks in. Right? Exactly. Hitching a ride.
For these animals, because right now in a majority of the states, but these animals are banned in some states for private possession already. Okay. Over 5 or 6 states for each of these covered species. They're brought in because it's legal to do so.
Okay, it's legal to do so. I didn't know that.
Yeah.
Okay.
Yes.
All right. Thank you, Mr. Chairman.
Oh, thank you, Mr. Chair. Thank you for the bill. I don't know who wants to answer this, but I'm curious. I'm not finding any incidents in Maryland where some people are injured by these animals.
We don't have cases documented of injury, but I would propose that the taxpayer money that went into, say, the zebra incident within Prince George's County, that was over 4 months of Department of Natural Resources, animal control officers, and law enforcement having to deal with them.
Understood. Thank you for that. But when I look at the number of the injuries by dogs in the state of Maryland versus the United States. It says 30 to 90 people are killed or over in the U.S. by dogs annually. 4.5 million people are bitten by dogs, with over 800,000 requiring medical care. Is this next? This is like.
Absolutely not.
So, but you're talking about money. I'm talking about, now we're talking about, if we're talking about real dangerous things. And then there was something in this legislation about dogs that are therapy dogs or not. What was said by the delegate? Did I miss something? You can go up to the podium, delegate.
Whichever you would yours.
Limited service animal.
Limited service.
Absolutely. So because 10621 is in the criminal code, the exception was made originally for primates, a very niche program back in the early 2000s that involved primates as assisted living animals. It was something that didn't take off within the country, and veterinarians and the Americans with the Disabilities have all come together to say, this wasn't a great idea. So we were just striking that language. We in no way want to affect service animals whatsoever. We're just striking that because that exemption was there. Striking the language about the primate as assisted service animals. That's the only reason that was there. We do not
about
dare
service
to touch.
Animals at all, not dogs,
at all.
nothing
no,
like
we
that.
love our service animals. No,
So-
absolutely not.
I mean, it just seems like that would be one bill, and then this is another bill. Because while I don't have a problem with the primate part as service animals, I do have a problem with people that are enthusiasts, that are people that are being responsible and how they, dogs getting into an area where a kangaroo in Virginia is housed safely and appropriately, that cause a kangaroo to jump a fence because they've got springy feet and can jump an 8-foot fence, is not, to me, is not that owner's problem. It's the dogs again.
Thank you for the observation and question, Senator. The point about that example, and that just happened to occur, that incident in Virginia that I cited, happened to occur less than a week before my hearing over in the House. And I wanted to, because you're going to hear more about that incident in Prince George's County where those zebras escaped and were on the loose for months, and what, the impact that had on county resources. But I wanted to see if there had been any more recent incidents in our part of the country involving any of these species, and I happened across the story of this kangaroo escape. And the point of that was sort of a backyard situation where this kangaroo was in an enclosure that the owner thought was safe and secure until this kangaroo was spooked by this dog and then leaps this 8-foot fence. It's the kind of thing that this bill is trying to get after, that private ownership of these kinds of wild animals is not sufficient to protect either the animal or the community where they might get loose.
So I'll counter that, delegate, with, if that's the case, I will tell you that there's no documented incidents with injuries from this bill that you're bringing forward. However, I can tell you that just in Maryland, there are over 8,000 dog bites reported annually with 3,200 insurance claims. Montgomery County, 1,329. Baltimore, 1,049. Anne Arundel, 1,001. They all see high volumes of bites, and these dog attacks are not something that we're looking to do to create. I mean, you talk about an expense. That's a large expense. But this bill is seemingly just very narrowly tailored for something that we don't have an issue with in Maryland. And I don't understand, again, why we would want to bring legislation forward that is pointed towards one specific group. And we've got other areas that are significantly more hazardous.
So respectfully, dogs are legal to own, and they are, and local animal management agencies, health professionals know how to handle those situations. The premise of this bill is that private citizens, and I want to make a point of saying that zoos, sanctuaries, other organizations like that do have that training, that do have safe enclosures, that do have experts on staff, are not touched by this bill, including there's a facility facility in your district, I believe it's Catoctin Zoo, correct? This bill does not affect a facility like that. It's the private ownership that we're trying to get at, especially people that own them as, I guess for lack of a better term, as pets. There was an incident that came up in Anne Arundel County a year or two ago where literally somebody in a suburban neighborhood looked over, the fence of her neighbor and saw a kangaroo in the backyard and thought, what in the heck, what is a kangaroo doing in this person's backyard? It's not illegal for someone in a suburban area to have a kangaroo in their backyard. And again, they're capable of, they're very strong. They are, I quoted my testimony, the males can be well over 6 feet tall, 200 pounds. They're wild animals. They're unpredictable. And we believe they don't, belong in private hands for people that don't have the training or the expertise in how to handle them.
And I appreciate that. And I'll just close with this, Mr. Chair, and I appreciate it. But respectfully, there are no documented incidents with anybody being injured in the state of Maryland by any of these. And yet we're looking to do this. And like for the example, if my zoo or the owners of that were to shut down, there's no clause for them to maintain possession of them until those animals were to expire.
Well, so, Senator, let me ask you, if we were able to look for, and we will look for statistics on any bites or attacks, are you looking for the people that own them, or because we're primarily trying to get at scenarios where they get loose? And again, you will hear, I hope, our testimony from Ms. Crooms about what happened in Prince George's and what havoc that situation wreaked on Prince George's County just a few years ago for 4 months, not 4 days or 4 weeks, 4 months, they were looking for these zebras and what that costs and the impact on those agencies. So are you looking for statistics on injuries or bites within the ownership of the people that have them or within the larger community if they've ever gotten loose, or both?
Both. I mean, we just don't have any, I don't see anything to support.
That doesn't mean it doesn't exist. We might just not have it right now.
Correct. And I don't see anything to support it, is what I'm saying. I see many other, we keep talking about the cost of that one call, but we're not talking about the 3,200 insurance claims last year in Maryland.
Right.
And how much that cost. So there's no direct nexus, in my opinion, to warrant this. And I just have those concerns where we're creating something and putting the proverbial, camel's nose under the tent, and then we're going to start adding on other things. And I just don't see the necessity. But
Thank
I
you.
appreciate it. Thank you.
Yep.
Thank you. My question is for Ms. Vloden. If you could, thank you. So we heard a little bit about some statistics related to dogs, but I'm curious as to the statistics related to the animals referenced in this bill. So how many of them are in Maryland total?
Thank you. So because they are not a regulated animal, we cannot answer. But I would go back to the point about the volume of the 2 that existed a decade ago that has grown to 34. So we can make some extrapolations that we have seen similarly, and I'm happy to get that information for you. But in general, these are unregulated, and the USDA doesn't monitor private possession of animals that are kept within privately held animals. They're only looking at the Class C exhibitors. So it's in general an unknown, but we can do the extrapolations for you and get back to you with that. Thank you.
Thank you. So on page 2, lines 29, I'm curious why the 10 days was struck down to 48 hours?
That was done originally when the bill was created 20 years ago, we didn't necessarily quite have in place some of the now better standards that we have related to traveling acts and circuses, things along that lines. So we are just trying to limit the animals that are from out of state that are traveling through the state that still have the possibility of escaping. Because again, the animal welfare community and the animal control professionals support the idea these animals really shouldn't be within our state other than essentially our zoos. But because people can travel through our state right now, entities that are not bound within Maryland we just want to keep them in the state as small of amount of time as possible.
That doesn't,
Is this the traveling through?
Right, so just to be clear, earlier you just were talking about private ownership. So I mean, if you're going it down from 10 days to 48 hours, are you also trying to stop the small circuses that may be coming?
No, they, as far as we understand, they get a license from the Department of Agriculture to exhibit. This is for genuinely, there are side-of-the-road type acts that we are trying to just kind of get the less professional, the less professional, there are literally people that will drive certain animals around the country to exhibit here or there. Not the USDA overseen acts that come to, I believe, many of our cities and towns.
So I'm curious, the vice, I mean, from listening to the examples that were mentioned, it was discussed about really trying to stop animals from getting loose. So I'm wondering if there is a better way, if you're trying to stop animals from getting loose, and I'm wondering, is it a better way of going to regulate rather than outright prohibition? Because, I mean, you talked about how we don't know how many are here. Well, if we regulate them, we'll know how many are here. Why are we jumping from one extreme to the next and just outright prohibition when, from what I'm hearing, there's really no demonstrated harm that's happening to humans. There is some fiscal loss when animals escape, but that could be addressed through regulation and maybe having certain guidelines on how these animals have to be kept for those who want to keep them.
Absolutely. Thank you for that. I would say that public safety is first and foremost the number one thing with this bill, but cutting back on the wild animal trade is also at the heart of this bill.
And that's what I'm trying to,
well.
so what's going on? That's what I'm trying to get at.
We felt like, this is a bad example for me to use, but two birds, one stone. If we're going to address this, go this route instead, because it does two things at one.
But if we regulate, could we get at some of these things? We turn this to a regulatory bill rather than a prohibition type bill?
I am open to whatever the sponsor would like.
Thank you.
Thank you.
My question is for the sponsor delegate, please. So the bill removes the exception for non-domestic animals used in assistant animals. So what happens to an individual who already currently relies on this animal as a assistant animal? Do they have to get rid of the animal? Do they have to move from the state of Maryland? Is there any kind of grandfather? Like, what happens to somebody who has this particular animal?
Are you talking about the animals that we're trying to get at, the zebras and the, okay, and your question is about who's grandfathered or?
Well, what's going to happen to somebody who relies on this animal as an assistant animal? They say it's an assistant animal. They have one in the state of Maryland. Your law goes through. What's going to happen? Do they need to move?
So there's only the one section on and someone commented that seems like two different bills. We are primarily after, the main purpose of this bill is preventing private ownership of the species. We talk about the zebras and the kangaroos and wallabies. Then there is this section on service animals, but we're not trying to take away anyone's service animals. We're striking language that is recognized by all these scientific groups about non-human primates, not dogs, not miniature horses.
Right, but your bill is together, and somebody who is using a zebra or the ones that you're trying to get rid of, if they feel that this is a service animal to them and it's their... I
mean, if they make that case, but I'm not aware of anyone that, for example, I will use zebras as the example, using them as service animals of any kind. If I'm understanding your question right.
That is the question, but it also gets to the point where the senator was asking what data of injuries that we've had and the costs and all those type of things. It seems that we're going down that road, but what exactly happens? So thank you for that question. The last thing,
And I'll talk to you further offline about
Absolutely. Thank you.
another thought I have. Thank you.
if I may. So there was in the testimony, there's a veterinarian, and he was talking about the similarities between zebras and horses, and zebras are smaller than horses. It almost seems like if we're going to put zebras in, and I know this is not the intent of the bill, but what stops for putting horses in? And in the example that you had used, that somebody saw a zebra and it took 4 or 5 days, I mean, does that not happen with horses getting out or cattle getting out? I mean, I understand your purpose, but what stops that to be the next thing? And it sounds like in the example, like, oh my gosh, everyone saw this zebra, not looking at it was a wild animal that shouldn't have been there. And then I push back on, we keep on protecting all the deer. And to me, deer do more damage to traffic and those type of things. So,
But respectfully, Senator, I appreciate that, but horses and cows, again, are domesticated animals, and people, my husband grew up on a farm in south central Pennsylvania, and the cows do get out from time to time, but people know how to get them back in, not so with zebras necessarily. One of the zoos in Maryland has it on their website that zebras can be calm and friendly, but they also have vicious kicks and very damaging bites. These animals are different, they're wild, and different in that respect than the animals you're citing.
well, according to the veterinarian who has testimony, that is not exactly the case. So, thank you. Look forward to talking offline.
And if I could answer your earlier question, any animal that is viewed as a service animal, if somebody were to argue, my zebra provides some level of, service, they would be grandfathered. People who currently own these species in all different circumstances, including a Cecil County farmer we're aware of that just uses them to graze and eat invasive species, they would all be grandfathered and would not be affected by this bill. Thank you.
Thank you very much. All right, well, actually, that's one part of my question, was that I'm actually not quite sure that that's true, that they would be grandfathered in, because the exceptions to the rule of that you can't import, possess, whatever, there is an exception for this service animal that you are bracketing out, and I don't see anything that says that you're grandfathered in if that section goes away that's being bracketed out. So I would just push back on that, A. And then second, and the committee knows that I tell a dad joke from time to time, and I promise this is not one of them. But so can you tell me what is a wallaroo?
Go ahead.
I mean, I know what it is, but could you tell the committee what a wallaroo is, please?
A wallaroo is a hybrid of a wallaby and a kangaroo. They do look like small kangaroos, essentially.
Could you also tell the committee what a zorse or
I'm sorry?
a zorse or a zonkey or a zebroid is?
These are all human-created hybrids of these, horse zebra.
Zonkey,
Yes,
zebroid,
zebra,
and a zorse.
donkey hybrids, things along that lines. I cannot comment to which ones can and cannot reproduce.
So those animals are not included in the bill. So if this facility or this guy in Prince George's County had a kangaroo, a wallaroo, which is a hybrid, or a wallaby, or a zebra, that's all now precluded. But if they crossbred them, then they could still have those other hybrids.
At this time.
Okay.
Yeah.
I was just wondering why they were omitted.
Because there's so many things that we can create that maybe have been created since the time we originally drafted this bill, that it's, until we see issues, we were not going to add. And I do want to add that in my testimony that's updated, I have just in the past 5 years, I believe there's an appendix of about 80 instances of humans being injured or severe encounters with these covered animals.
Back to the first point, though, if someone,
Sorry.
so now, I don't think the grandfathering actually happens in the bill,
Okay.
but if someone had something like like one of those like macaques or those little like capuchin, those little monkeys that help out, so this bill would say you can't have that anymore to help you out.
It shouldn't. That was not our intention.
Okay.
Clarify that.
But if it doesn't qualify, I mean, it brackets out a couple of, if the person has a disability that severely limits mobility from possessing an animal specified in the subsection, and then those are non-human primates, monkeys, or these little small monkeys.
Okay.
The exception is now gone for those. So, I mean, I get to Senator McKay's point, if someone has a service animal that's like a monkey, for instance, or a little tiny monkey, those are now going to be out.
That was not
I don't care.
my
I'm just wondering-
intention,
I just wanted- I'm
but,
trying to
but
understand, yeah.
absolutely, we are happy to work on that as
can
well if
clarify
needed.
that, Mr. Chairman.
Absolutely.
Okay.
Absolutely, 100%.
It's a fascinating bill. I appreciate that. It's like that Western riding style bill you had last year, like a couple years ago. That was a good one. But all right, we're going to switch to the panelists joining us virtually, and now we're all going to look up Zorses and Zebroids on our laptops. But we'll start off with Lisa. Welcome, Ms. Radoff.
Hello, Chair Smith, Chair Waldstreicher, members of the committee, thank you for the opportunity to testify before you today. My name is Lisa Radoff. I'm the President and Chair of Maryland Votes for Animals, here in support of HB 53. You've already heard compelling testimony and some excellent questions. So I really just wanted to respond to one or two of them because we already prohibit private ownership of certain animals like bears, primates, wild cats, and venomous snakes. So in other words, whether anyone was injured by a primate when we passed that legislation, I'm not sure, but I think that there's just the sense with this bill that because we have had issues in Prince George's County, and as somebody who used to own an insurance agency, a lot of potential for property damage as well as personal injury. This is about prevention, protecting people, safeguarding communities, and ensuring that wild animals are not placed in situations where they and others are at risk. In one of the other states, not in Maryland, a man got a little drunk and decided to do some boxing with his kangaroo, and he was killed because the claws of the kangaroo were so sharp that, you know, he was mauled to death. And, you know, so we want to protect people from those type of instances. I did not plan this, but this is the environment. This is Amboseli National Park, Mount Kilimanjaro. You probably can't see in the background, but that's where zebras belong. So when you think about zebras and, you know, their native area, I don't have Australia, so apologies for the kangaroos, but these animals, zebras, kangaroos, wallabies, and wallaroos are wild animals, and they should not be pets. As you heard, there are exceptions for zoos, for private ownership, for people who had these animals before October 1st of 26 and are licensed with their animal control by December 1st of 2026. So there are exceptions to this rule. It's just pure and simple private ownership that would be prohibited. And with that, I'd like to ask for a favorable report. Thank you.
Thank you so much. And our second witness, the captions are blocking your name, but please go ahead. We are ready for your testimony.
Absolutely.
Thank you.
My name is Andrea Krooms. I was the director of the Department of Environment in Prince George's County and thus oversaw animal control in 2021 when 3 zebras escaped from a herd of approximately 50 in late August 2021. Over the next 2 years, until the criminal and civil cases against the owner concluded in October of 2023, I spent an inordinate amount of time working on catching zebras, studying zebras, exhuming zebras, and doing zebra autopsies, investigating criminal and civil infractions, and prosecuting the owner of those animals for negligence. I am here today to express that cost, in dollars and in time to local governments, of overseeing individuals who own exotic animals is untenable. One of the senators raised the concern of, could we just regulate our way out of this? The cost to do so would be exorbitant, I believe, because there is no state agency that oversees exotic animals. That responsibility falls on counties and municipalities. The knowledge of exotic animals, both from animal husbandry and legal compliance perspective, is not commonly known. I served as a criminal attorney for the state, and I have a master's degree in agriculture. I've taught veterinary science at the university level, and before this happened, I didn't know jack about zebras. I was also a rodeo champion and, member of FFA. I can catch a cow. I just caught one 3 days ago because I live in South County, Prince George's County. Catching a zebra took us 4 months. Local governments just don't have the tools to catch these animals. We don't have the facilities to house them. We don't have the expertise to monitor their health and safety. And we don't have the relationships with the federal bodies that govern them to the limited extent that they do to effectively protect the safety of the public or the health and wellness of these animals. So for those reasons, I would advise on and request a favorable report on this bill. Thank you.
Thank you so much. Questions for our virtual witnesses? All right, seeing no questions for the proponents, we'll now go to the opponents of the bill. In person, I have Mark Wiesner, and then we'll go directly to our virtual testimony, Jeff Oliver and Patrick McSweeney. And then okay, Mr. Oliver is not here. Mr. Wiesner, are you here? Come on up and we will take your testimony.
Good afternoon. My name is Mark Wiesner. I'm a farmer and a small business owner in Caroline County. My wife and I raise exotic animals and livestock for 41 years. We're a USDA licensed facility. We have red kangaroos and a Grant zebra that we use in our education program to bring conservation awareness and a love of animals to many children, families, youth groups, and special needs individuals. Conservation of species only happens when people can relate and interact through hands-on exposure to the animals. This bill unfairly targets these species and their ownership. Maryland Health Department reports for bites and non-bite trauma from 2015 to 2024 show there were 72,920 dog events. There were 1,318 raccoon events, while kangaroos, wallabies, and zebras accounted for 1. There were 41 species with more events than kangaroos, wallabies, or zebras. There's no documented crisis with these species. Lawful owners and exhibitors should not be penalized without evidence of harm. Conservation of species requires a strong and diverse gene pool. Policies that restrict populations or eliminate private ownership reduce genetic diversity, which weakens the ability of the species to survive over time. Maryland already has existing laws that address public and animal safety concerns. My children and grandchildren have grown up knowing one of the strongest bonds available to man. That's the love and the trust that is established when these animals accept you into their lives. It's not acceptable for unwarranted legislation to take this opportunity away from them and future generations. House Bill 53 is harmful to compliant small businesses and educational exhibitors. I urge you to vote no to this bill. Thank you.
Thank you for your testimony. We'll go with Mr. McSweeney virtually. Please unmute yourself and then you're good to go, and then we'll take questions after if there are any. Mr. McSweeney, you are muted. If you could unmute yourself, please, and then go ahead.
Sure, sorry. Hi, can you hear me now? Perfect. Yeah, I'm Dr. Patrick McSweeney. I'm a veterinarian from New Orleans, Louisiana. And I've been a veterinarian for 42 years. I started my career at an SPCA clinic that I defended to the Louisiana Supreme Court level to protect animals that belonged to people that were from inner city and couldn't really afford good care. I'm a member of the Association of Zoo Veterinarians, and I do work for many private zoos. So like today, I have to check 9 giraffes when I leave here, and I'll check a mob of 26 kangaroo at one private zoo, and then I have 4 kangaroo to check at the other private zoo. I can say that the most amazing animal that I've ever seen is a platypus. It's a mammal that lays eggs, and those eggs hatch out mammals. The platypus has no nipples. She oozes milk from her side, and the babies lick that off. But next to that is going to be the kangaroo as one of the most amazing, incredible reproductive creatures that I fool with. They're non-eutherian. They have, after they're bred, they produce a baby that stays in its uterus. They have 2 vaginal tracts, 2 cervix. The baby can sit in there for up to a year until the mama signals for it to actually start going through going back through mitosis, to which it climbs out as a little bitty red bean and gets into her pouch and attaches to one of 4 nipples. And that's the first time she's ever attached to her mother. The only problem I've ever had fooling with kangaroos, the big gigantic boomers, the big red males, if they're bad enough, we'll dart those guys to fool with them if we have to. But the others, typically we walk up with a bottle, and big kangaroos will take a bottle. They love their bottle. So they'll stand up on their tail, put they usually exteriorize their penises, to which I say, you're not going to need that today. And then we'll offer them a bottle. They'll come up, take their bottle, then I'll walk up behind them. They don't have kneecaps. They can't back up. So I can get up behind them and pop them in the behind with something and drop them. And that's how I can fool with them without being hurt in any way. But I don't find them dangerous animals at all. Any questions? I'm sure you have a trillion questions, but if you have any questions, please ask me. I'm an expert. So, I mean, and I've been a vet for a long time.
All right. Questions for the opponent, Senator James.
First of all, I just want to thank you all for coming down, and I want to thank the sponsors who I know well and the support people. But it's so helpful to us. So don't ever think it's not really helpful to us that both sides come down here and give us lots of information. To you who have a business, and thank you so much to the veterinarian who's taken time out of his busy day and far away from us. I'm reading your testimony with great fascination, and I don't think that we'll do anything with this bill until we deeply consider everything that you all have told us, and we may even reach back out to you. But to both of you, the way I do read the bill is that I do think your business is not touched by this bill. I could be wrong, but that's how I read it. You have a fine business, and it should continue to move forward. And so that would be to you. And to the vet, I'm sorry, Dr. McSweeney, when you get a moment, just explain to me. I totally appreciate what you're saying. I just watched a documentary on kangaroos, been to Australia. I'm trying to figure out whether you think they would be appropriate, pets for just ordinary individuals, or are you more comfortable with the way we have a gentleman here who runs a very fine business? He knows how to take care of them in the state of Maryland, and people come to visit his animals, but I don't think he's advocating that, some guy everybody on the corner ought to have a kangaroo in their backyard. So first to the businessman and then to the vet.
Well, the USDA license is only required for me to be able to exhibit to the public.
Right.
But private ownership, there are a lot of people that want to have, kangaroos are very enjoyable animals, as your dog would be, or your cat. And the availability, both as breeders for one, places to sell, and two.
So you do that as well, is that what, or you're knowledgeable about that part of the business?
I am. And we also, if I decide the USDA exhibitor's license says and your new bill says that I have to be actively exhibiting at all times in order for that exemption to stay in place. So I'm not the youngest man out there, but if I decide at some point that I want to retire, the animals that I have and have dedicated to care for the rest of their lives, that's saying my children would then be out of compliance, because unless they go to the USDA, set up their own separate facility,
So we really needed to hear that from you. And to the vet, is your testimony that you think they should be, that they could be as ubiquitously as dogs and cats? Or are you just asking us, and I agree with you, that, for example, kangaroo are prey, not predators. Males, when they're mating, are pretty vicious, but other than that, in other words, what are you trying to say to us other than to be far more knowledgeable about these animals before we legislate about them?
I don't know that I don't think it's going to be as common as having dogs and cats. My position in court, because I represent the court as it relates to animals and animal welfare. So I mean, I'm going to carry a badge that, they appointed that. So the fact is that, dogs and cats, because we know so much more about them with regards to having them as house pets. But a kangaroo, I'm 6 foot, 200 pounds. So big, a big male kangaroo is called a boomer if it has its testicles. Okay, and I do. So they're 6 foot tall. They're 200 pounds, and they're So of course their size can be a little intimidating because they can lean back on their big old tail and stand up on their tiptoes and they drop their head. And of course, like I say, exteriorize their penis. But it's like they do all that kind of stuff to kind of be big, but till they see their bottle, and then they come down, they come and drink their bottle, and they're like, hey, they're just big babies. But I don't think everyone in the world should. I don't want to see kangaroos in the French Quarter.
Right.
If that's what you're asking me, no, it isn't like that. They're not to be played with. And I think anyone's ever been injured by one probably tormented the hell out of it to the point where it finally had to strike out. And if it did, well, good for the kangaroo, as far as I'm concerned. I mean, in these, a man was killed by a kangaroo. Well, that's a one-off. That's not a statistically relevant fact, okay?
Yeah.
When you look at what I wrote, in Australia, it's a huge continent. They're 3-to-1 kangaroos to people. And there've been 2 deaths in 100 years.
Right. That's very, very helpful. Thank you so much for giving us all that great information. Thank you.
All right. Any other questions for the opponents of the bill? All right. Seeing no questions, that completes the hearing on House Bill 53. Delegate Lehman, we know you have another bill. Did we lose Delegate Lehman? Oh, there you are. But I'm trying to balance the needs of lots of delegates here, and that's an impossible task. But if we could just get Delegate Plakovich-Carr on behalf of the Montgomery County delegation, and then Delegate Lehman will hope to move back to you shortly as I try to juggle the schedule here.
Thank you, Mr. Chair. Good afternoon, Senators. It's good to be here for the first time this session. For the record, I'm Delegate Julie Plakovich-Carr on behalf of the Montgomery County House delegation. This local bill would just allow 2 municipalities in my district, Rockville and Gaithersburg, to opt into the existing pilot program for use of automated enforcement cameras at stop signs in school zones. As this committee knows well, in 2024, we authorized Prince George's County and its municipalities to use this type of cameras, and we're getting some very promising data out of several jurisdictions in Prince George's County about significant declines in violations since the deployment of those cameras. And last legislative session, we expanded the pilot program to also include Tacoma Park and parts of the city of Baltimore. So this would just add 2 more jurisdictions to that existing pilot without making any changes to the pilot otherwise. I think this is an important bill for my district because there are many students, 1 in 5 Montgomery County public school students who do walk to school, my son and my family included. And unfortunately, this is not just about safety for students, but also for other pedestrians. There were 2 residents of Gaithersburg who were tragically killed in 2022 when they were walking home from voting at the elementary school in their neighborhood. A driver failed to stop at the stop sign by the school and struck and killed both of those residents. Both municipalities are in full support of this bill, and it passed both the Montgomery County Senate and House delegations unanimously. And I ask for a favorable report on this local bill.
Thank you, Delegate. Any questions from the committee regarding this local bill? Senator Sidnam.
Thank you, and good afternoon. You mentioned data. Is there something that you can share with us? Because I know we've had, when we heard on Baltimore City, and I guess you said Montgomery County, but I don't remember anyone ever mentioning data.
Yes, the data I've seen so far has been for several municipalities in Prince George's County, and Senator, I'd be happy to circle back with you with that information. I don't think I've seen it yet for Baltimore. I think it's still too new there.
Okay, because from what I was hearing in Baltimore, although they've been authorized, I don't think they're doing anything. So in this case, you're actually doing something and have information, which I would be curious to see.
Yes, happy to circle back.
Thank you.
Thank you, Delegate. Any further questions? All right, seeing no questions, that completes the hearing for House Bill 601. Delegate Vogel, why don't you come up? I know this one will be quick, and then Delegate Lehman, we will return to you. Delegate Vogel with House Bill 80.
Thank you, Mr. Vice Chair. Senators, I've learned so much in the last hour. I'm here with House Bill 80, which is a very simple bill to protect renters against unexpected fees in their rent. We know that renters are charged all sorts of mandatory and optional fees, and what this bill requires is that those fees be clearly outlined in the initial lease so that renters can know exactly what they're signing up for. There was a very interesting story in the Washington Post, I believe, last year about renters being surprised by hundreds of dollars in additional monthly fees on top of a rent. They were not expecting to be paying those fees and as such faced financial hardship. So I respectfully ask for a favorable report on House Bill 80.
Thank you so much. Senator West.
Finally found my voice. Good afternoon. I'm looking at the testimony of the Maryland Multifamily Housing Association. They want a small amendment deleting a couple of lines on page 3. They say that there's an inconsistent patchwork of laws throughout the state for housing providers which operate in multiple jurisdictions. This becomes complicated. So the state should set one policy without local jurisdictions enacting their own set of laws. What do you think about that?
Senator, thank you for the question. We have taken a number of amendments from them, including exempting trash fees and removing, striking minor and from minor violations. I do support local control, and I know that a number of our municipalities and counties have taken slightly different measures than what this bill requires as it relates to junk fees. I don't think it would be fair for us to step in and preempt those measures. Thank you, sir.
Further questions for Delegate Vogel? All right. Thank you, Delegate Vogel. Seeing no further questions, that concludes the hearing on House Bill 80. We really appreciate it. Now let's go back to Delegate Lehman with your second bill, House Bill 200.
Thank you, Mr. Chairman. I would like for my intern to present this bill. She's been working hard on it all session, and I thought it would be a great experience for her. I'm going to remain right next to her in case you have questions. Thank you.
Got it. This is JPR. Welcome to JPR.
Good afternoon, Chair, Vice Chair, and members of the Judicial Proceedings Committee. For the record, I'm Silvana Martinez, asking for your favorable consideration of House Bill 200. This bill protects both sellers and potential buyers of residential real estate through disclosure of a property's flood risk. Beginning July 1st, 2027, a seller of residential property must disclose specific flood risk information to the buyer prior to entering a contract of sale. The flood risk disclosure form will be developed and published by the Maryland Department of Environment. A flood risk disclosure statement must be provided by the seller to the potential buyer before she or he enters the contractual phase of a purchase. This disclosure will include critical information such as whether the property is within a designated special flood hazard area or a moderate risk flood hazard area, whether federal law requires insurance on the property, whether the seller has received any financial compensation from a federal agency for flood damage, whether the current owner has flood insurance, and whether the seller has knowledge of flood damage caused by a variety of sources, including heavy rainfall, coastal storm surge, tidal inundation, or river overflows. This bill was amended in the House Economic Matters Committee to limit the reporting to buildings with 4 or fewer single-family units, exempt newly constructed foreclosed or tax sale houses, houses that will be converted to another use and unimproved real property, as well as to remove the requirement for the seller to supply accounting of redemption of flood damage claims, and finally remove the requirement to disclose the number of times that flooding has occurred. According to FEMA, 1 inch of floodwater can cause up to $25,000 in damage, which can be crippling for many homeowners. While this bill does not require Maryland residents to purchase flood insurance, it can drive them to do so. As climate change continues to make extreme weather events and catastrophic flooding more common, this bill protects Marylanders and ensures an extra level of emergency preparedness. As of now, Maryland's real property disclosure statement only includes 2 single questions sections regarding the readiness of a structure to take on water. These questions are about the basement and the roof and whether there is evidence of leaking or moisture. Flood disclosure laws have been adopted in 30 states. Flood risk disclosure in Maryland is important with its unusual geography. In addition to its Atlantic coastline, the Chesapeake Bay has 11,684 miles of shoreline with its thousands of tributaries. According to the Department of Natural Resources, the Maryland coastal zone extends from 3 miles out in the Atlantic Ocean to the inland boundaries of 16 counties plus Baltimore City that border the Atlantic Ocean, the Chesapeake Bay, and the Potomac River to the District of Columbia. That area encompasses 2/3 of the state's land area and is home to 70% of Maryland residents. In closing, I want to acknowledge the assistance and support of the Maryland realtors who understand that flood risk disclosure safeguards for all Marylanders, property owners, and sellers alike. I respectfully ask for a favorable report.
Thank you. Questions? Senator Muse and then Senator West.
You have to go to the podium for this one. I want to combine the last bill with this bill. My mom had a zebra that was supposed to have in her hearing aid, her hearing zebra. Oh, okay, I'm sorry.
Yeah, I'm having a hard time.
My mom had was hard to hear, and she had a zebra that was supposed to have been her interpreter. The problem was she thought the zebra was deaf because the zebra would never say anything to her at all. So I'm wondering, what would be your answer or remedy to that? I want to talk to your student. Intern. What would be your answer to fix them so that we don't have to lock them up?
For the bill that the Seaver bill?
So I want to make sure we get to everyone here who has a question. Senator West is next.
That's a good answer. Great. Thank you, Roger.
Thank you. So I guess my question relates to people who sell the houses on their own. If you use a real estate broker, presumably the real estate broker would be aware of this law if we were to pass this law and have access to these forms and be able to find out by sourcing information where flood zones are. But if you have someone who's selling his house by himself and without using a real estate broker, it's going to be hard, isn't it? How do we expect homeowners who want to sell their houses without using real estate brokers to navigate this kind of a law?
So thank you, Senator. If I understand your question, I do think most people are aware whether their property is in a flood zone, but certainly FEMA maps are available pretty broadly to the public. And this would apply to brokers as well as an individual selling his or her home, as long as they're not exempt under the various exemptions that we mentioned in the testimony.
Well, I can tell you, I'm familiar with FEMA maps because I'm a lawyer. And when I was actively practicing, I did a fair amount of real estate work. But I'm not sure your average citizen, the citizen probably has an idea whether his house is in a flood zone or not, because if he's been living there for a while, he's either experienced high water or not. But this requires more than just personal observation. This requires more specific data. Does the bill contain any suggested way for someone selling his house by himself to obtain this, find out, well, number one, to know that this requirement exists, and then because if you don't know the requirement exists, I assume that the person can rescind the contract of sale if the information is not provided? That's normally the recourse. If you don't get the required disclosures, you can rescind the contract.
Right, so the disclosure is specific before they enter the contractual phase, so they haven't signed off on anything without knowing this. Right. MDE is involved in developing this worksheet, so there would be information, through the state. The realtors do a good job of getting the word out in their own community when laws change. Just like when any law changes, there are different, public information campaigns, efforts to get the word out. But certainly with MDE's involvement with the development of this worksheet, there would be that level of state engagement and the availability of MDE as a resource, as well as the realtors and others.
Okay, thank you for your answers.
Thank you.
Thank you. Any further questions for the delegate? All right, seeing no questions. Thank you, Delegate Lehman.
Senator McKay.
Oh, I'm sorry, Delegate McKay. Senator McKay.
Thank you, Delegate, for bringing this. It's an important bill, and I appreciate you doing so. Being somebody who dealt with in 2025 floods that really devastated the Georges Creek area in Allegheny County, because that only happens every 30 years, and therefore when properties are being sold and that kind of stuff, that will slip from somebody's mind that they're purchasing a property that probably will flood again. If I'm not mistaken, the bill does talk to give a FEMA evaluation certificate, and that's if it's only available. That's what the bill talks about. So
yes,
it says prior to the contract of the sale, the seller real estate property must provide a complete flood risk disclosure from the purchaser. The seller must also provide, if available, a copy of the FEMA evaluation certificate. And so I tend to believe that there's a little bit a caveat out if somebody doesn't know about it and can't provide that piece of document that may or may not be available. So Thank you for bringing.
Yes, thank you. That's right. Thank you, Senator McKay. Thank you for your comments.
Thank you so much. All right, that concludes our hearing on House Bill 200. I saw Delegate Warman here. Delegate Warman, if you want to join us, you'll go next with House Bill 963. Is Delegate Williams with us? You'll be next, Delegate Williams. Okay, I do not see Delegate. Okay, yep, okay, I see you. Thank you.
Alrighty. Thank you, Mr. Chair. Thank you, committee and members of the Judicial Proceedings crew. For the record, I'm Delegate Teresa Warman, representing District 16, and I'm here to present House Bill 963. This is the second time this committee has heard this bill, and you saw it last year after it passed out of the House with bipartisan support. And we're back again this session, hoping we can get it across the finish line. During the interim, I met with members of this committee, including Senator West, thank you so much for your help, who's a bit of an expert in this field and had raised questions last year, and I really appreciated the conversations and the opportunity to address those concerns. This bill would remove an outdated provision in our Estates and Trust article that prevents someone from managing their loved one's estate simply because of their citizenship status. This bill came from a very real and painful situation. Maria del Carmen Castellon Quintana is the widow of Miguel Luna, one of the 6 construction workers who tragically lost his life in the collapse of the Francis Scott Key Bridge collapse. While navigating unimaginable grief, she learned that because she's not a U.S. citizen, she was barred from serving as a personal representative for her husband's estate, even though they shared finances, shared property, and shared a life together. She had to hire attorneys to help her navigate the process, and she has still not settled his estate to this day, a day before the 2-year anniversary of the collapse. Over the interim, like I said, I worked on this issue, and it became clear that it's not just limited to this tragic case. Maryland, and particularly my district, is home to many diplomats and international students, researchers, and just families who have built their lives here in the United States over many years. And when something happens, current law can create unnecessary barriers during the probate process at the exact moment that families are grieving. Importantly, this bill does not remove any of the meaningful safeguards that are already in Maryland probate law. A personal representative must still be an adult, mentally competent, not convicted of a serious crime, absent good cause, and either named directly in the will or be entitled under statutory order of priority. Courts and registers of wills retain full authority. This bill is about making sure that in moments of grief, Maryland families are evaluated based on their ability to fulfill fiduciary duties, not their passport. I respectfully request a favorable report, and there's more complete testimony in your packet. Thank you very much.
Thank you so much, Delegate Warman. Any questions for Delegate Warman? Senator Love.
Thank you, Mr. Chair. Good afternoon.
Hello.
Last year, when we were discussing this bill, one of the questions that came up was with a non-citizen personal representative potentially leaving the country with estate assets. Could you talk to us a little bit about that, please?
Thank you for that. Yeah, those were some real concerns. But these folks are still fiduciaries under the law, so they're still subject to court supervision, accounting requirements, and removal for cause. And I will, say that citizenship does not prevent misconduct. A U.S. citizen currently has the same idea, theoretically, to misuse state assets, and that's why our laws focus currently on the accountability and oversight, should focus on that, not nationality. And we checked, and there is no evidence that this restriction prevents fraud. There's safeguards in place already, and we checked, and the one person that did do this was a citizen, and it happened once in many cases that we've had this issue come up. So we don't think that should be an issue. Thank you for the question.
Thank you, Mr. Chair.
Thank you so much, Senator Sidnor.
Thank you. Can you remind us, why is this prohibition in the current law?
It just, the current prohibition is just limited to permanent residents. So what we're trying to do is just strike the provision under the article that says that you have to be a U.S. citizen or a lawful permanent resident. It just excludes a lot of people that are here, not just undocumented immigrants, but just people that are diplomats and.
No, get all. I'm just trying to understand. Do you know the history of why it is in the current law?
No.
You know. Okay. Thank you.
Appreciate the candor. Any other questions for Delegate Warman? All right, thank you, Delegate Warman. That concludes the hearing for House Bill 963. I see that Delegate Harrison is here. Delegate Harrison, we have you for House Bill 557, occupational licensing.
Good afternoon, Mr. Chair and members of the Judicial Proceedings Committee. I am Delegate Andrea Fletcher Harrison, here to present HB 557. I know that this is sponsor only, but if you have questions, there are some other members from the Department of Labor and the Health Occupations Boards who may be able to answer your questions if you have them. I have brought forth this legislation to reduce barriers to reentry for people who have been formerly incarcerated by strengthening and standardizing Maryland's predetermination review process for occupational licensing and certification. It is important to me that people have second chances to lower the likelihood of recidivism, encourage successful reentry to society in our communities, and help support Maryland businesses that rely on stable, qualified workforce. HB 557 updates our criminal procedure to formally establish a clear, binding predetermination review process within the Departments of Agriculture, Environment, Health, Department of Human Services, and the Maryland Department of Labor. Under the bill, an individual may request that a relevant department review their criminal history in advance to determine whether it would disqualify them from obtaining an occupational license or certificate that they seek. The department's decision on that request is binding unless there is a subsequent direct and material adverse change to the individual's criminal history, giving applicants certainty before they invest their time and money into training and education. The bill requires departments to use existing resources to conduct these reviews, and when a license or certificate would be denied, to provide an explanation that includes the basis for the denial, such as a direct relationship between the offense and the license or an unreasonable risk to public safety. HB 557 also preserves important public safety sideboards by maintaining exclusion for crimes of violence and by specifying the section does not apply to individuals seeking licensure or renewal under Title 11, Subtitle 6 of the Financial Institutions article. In addition, the bill clarifies that the predetermination process does not apply to health occupation boards regulated under Titles 1 through 21 of the Health Occupations Board by respecting existing professional regulatory frameworks. And by the way, that is an amendment that you should have in your packet. We did try to ensure that it was here before because we missed it on the House side. So HB 557 allows individuals to submit a revised request for predetermination either 1 year after the prior decision or when there is material change to the criminal history, such as completion of supervision or additional evidence of rehabilitation. The bill also authorizes the departments to change a modest criminal history review to charge a modest criminal history review fee of up to $100 with a required waiver for individuals whose income is at or below 300% of the federal poverty level as determined by the District Court of Maryland. This structure ensures that agencies can manage workload while keeping the process accessible for low-income Marylanders who are often the most affected by collateral consequences. Maryland law already recognizes that it is the policy of the state to encourage employment of nonviolent ex-offenders and to remove unnecessary barriers to their ability to demonstrate fitness for occupational licenses or certifications. Current data show that previously incarcerated people face unemployment rates many times higher than the general population, and those barriers are especially acute during the first few years after release. With stable employment to when stable employment is critical to successful reentry to public safety. With approximately 19% of Maryland jobs requiring a license or certificate, ensuring a fair and transparent path to licensure can unlock economic opportunity, strengthen families, and reduce recidivism. The predetermination process created and clarified in HB 557 is about honest and individualized review of criminal records before returning citizens invest their valuable time and money into a desired profession. It asks departments to look at the nature of the offense, the time elapsed, the applicant's rehabilitation and good conduct, and the actual duties of the license instead of treating any record as an automatic disqualification. This approach aligns with what employers and workers across the country are already saying. When safety can be protected, they are willing to hire and work alongside people who have formerly been incarcerated. Everyone has a past, and it is our responsibility as lawmakers to ensure that the past does not permanently define anyone's future when they have demonstrated rehabilitation and a desire to contribute. HB 557 gives Marylanders with records a fair chance to understand whether licensure is possible before they invest in training while preserving appropriate safeguards for public safety and existing regulatory structures. Together, we can continue to improve outcomes of returning citizens, Maryland businesses, and the communities that defend both. Again, I'll repeat that I'm offering this amendment, which we missed in the House. I apologize for that, but we ensured that it was over here, and I'll even give you the amendment number if you need it. Hopefully, you do have it in your packets. So that it excludes the health occupation boards. And we do have someone here from the Health Occupations Boards to testify that we have been working very hard together, as well as the Department of Labor. So I thank you for your time in hearing me, and I urge a favorable report on this bill. Thank you.
Thank you, Delegate. Questions for Delegate Harrison? All right.
I took care of it all.
What's that?
I said I took care of it all, no questions.
Yes, you did. Thank you, Delegate Harrison. Council has access to the amendment, so we should be good.
Great. Thank you so much. I appreciate it. Thank you so much, sir.
All right, that concludes the hearing on House Bill 557. Delegate Simmons, I do see you there. We've got some witnesses on your bill, so we're going to hold it and kind of cross off some of these bills. I see Delegate Terrassa representing Howard County for House Bill 1169. So let's take that next, because that will move quickly.
All right, thank you very much. I appreciate it. Give me 1 second. All right, good afternoon, Mr. Chairman, Vice Chair as well. For the record, and esteemed members of the committee, for the record, I'm Delegate Jen Terrassa. Thank you for this opportunity to present House Bill 1169, which is a local bill requested by a member of the Howard County Council to address road safety concerns from residents, something I was familiar as a former county council member. We've all been on those roads, like cul-de-sacs, for example, where we know the 25 miles per hour is just too fast. Think about a small cul-de-sac where children ride their bike or play catch. Neighbors want the folks to slow down. They place slow children at play signs along the road. And they come to their county council members and say, 25 is too darn fast, please lower the speed limit. However, under current state law, most local governments are prohibited from posting speed limits below 25 miles per hour unless the state specifically gives them permission to do so. As a former county council member, I remember this frustration when people came to us. And we know lowering the speed limit would make the streets safer for children on the street. So House Bill 1169 simply adds Howard County to the section of Maryland Code already allowing Montgomery County and Anne Arundel County to lower the speed limit to 15 miles an hour. Note, there are no added speed cameras with this bill, and this doesn't change the speed limit in Howard County. What it does is authorize Howard County to lower the speed limit on a case-by-case basis after conducting a traffic study. The vote was unanimous in the House delegation, and I believe you also have a letter from the Senate delegation. If you don't, you should by tomorrow, but I'm told it was sent over here. House Bill 1169 will provide Howard County with essential flexibility to respond to specific safety concerns, reduce crashes, and keep everyone safer. I respectfully urge a favorable report on House Bill 1169.
Thank you, Delegate Terrassa. Questions for the delegate on this local bill? All right, seeing no questions, thank you, Delegate. That
Thank you
concludes
for
the
getting me in. I
hearing
appreciate it.
on House Bill 1169. Delegate Simmons will go to you, and then I know Delegate Williams, Chief of Staff, is here and will go after this bill, and that Delegate Williams' bill will be the final bill today. Delegate
I do have a panel. May they come up? Okay, awesome. Thank you, Mr. Chair, and members of the committee. Delegate Gary Simmons, represent District 12B, here on House Bill 713, distribution of literature, the purchase of firearm and ammunition. This bill is coming back from last year, was presented by Senator Lamb at that time, and cross-filed myself in the House. This is about literature that would allow for, when you purchasing a firearm or ammunition at any of the authorized dealers, to be given a pamphlet. This pamphlet would contain information on mental health resources and other resources that will be provided by the state Department of Health and distributed through the county Department of Health for the purposes of issuing it at the point of purchase. This is to make sure that we're giving out correct information and literature to help in the event of a crisis or other things that may take place with those individuals that are in possession of a firearm and ammunition. You may have where opponents may feel that this is an encroachment on their rights, but it's better to have the material and not need it than to need it and not have it. This was also challenged before the U.S. Supreme Court, and they took no position. It was returned back to the county for that reason. I'm asking for a favorable report on it as well. There is civil penalties that are a part of this process as well. There is a scale of first offense of anything from $0 to $500, and then second offense is $500 to $1,000 that can be levied upon any violators of this law. So with that, I ask for a favorable. I also have my panel here for further testimony. Thank you.
Thank you, Delegate. Let's take the testimony, and then we'll have questions afterwards. Mr. Bellamy.
Thank you, Chair. Will Stryker, members of the committee, Lorenzo Bellamy, on behalf of Teachers to Unify to End Gun Violence in favor of House Bill 875. Thank you, Delegate Simmons, for your sponsorship of this bill. Teachers Unify is a grassroots movement of educators and school staff across America, educating, advocating, and demanding safety from gun violence in their respective communities. Teachers Unify has submitted written testimony, so I will not go into detail about what they do, but you can read their written testimony. One of the issues that I was hoping to get some clarification, because I did testify on this bill last year. So in Senate Bill 577 last year, the fiscal note said that it would cost anywhere from $25,000 in FY26, $25,300 in FY27, and $26,000 in FY30 for the Department of Health to publish and make available sufficient copies of the required literature. Now, for this bill, the fiscal note says that the cost for FY27 is almost double, $41,800, going all the way up to $52,200 by FY31. The only difference that I can see in this bill versus last year's bill is a difference in the amount of FFLs that would be impacted. So last year it said 750, this year 785. So essentially for 35 more FFLs, the bill is essentially doubled. Now I did make note that they are adding the requirement to hire a part-time person, but I still don't think that this justifies such a high fiscal note. And even if it does, I think that this is still affordable. Like I said, notwithstanding the cost increase, I believe that this bill should meet the affordability test. During the House hearing, there was testimony by the opposition that said this bill will accomplish nothing. And I would say that, well, if a firearm purchaser reads the pamphlet and the pamphlet contains this information, I think it's worth it if it saves a life. And finally, the opponents also testified, and I hope they won't say this again, that the FFLs will tell the firearm purchaser to put the document in the trash. I think this is irresponsible, and I think that FFLs are not by default bad actors. So with that, we urge a favorable report on this bill. Thank you.
Thank you. Questions for this panel? Go ahead, Senator.
Yeah, if the delegate come back up. Thank you for the bill, Delegate Simmons. I'm curious, when we look at requiring, so do you own any firearms?
I do.
And when you purchased those firearms, what came with those?
It came with a box. It came with, information in reference to the firearm.
Firearm safety?
Correct.
In the box?
About the firearm itself, yes.
And firearm safety?
That's correct.
Correct. Okay, so that's good to know. So I guess what I'm looking at is, when we're looking at now, requiring FFLs to put on display information that is could be considered outside of what would be purely factual and not controversial. Do you have any comments on how you feel that what you're asking to be put on here to be purely factual and uncontroversial?
Are you referring to the material?
Mm-hmm.
So that would be the responsibility of the health department to design a pamphlet with information pertaining to mental health and things around weapons safety. That will be an event of a crisis or something that can be used as an intervention tool for that purpose.
But I guess what I'm asking is what does that Maryland Health Department have training-wise relative to firearm safety, firearm training? Obviously, they have some things around mental health awareness, suicide prevention. I would say that those may even go together.
Right.
Conflict resolution.
Right.
I'm unclear on, then they have to distribute it, and then there's a penalty. We want to give them the authority to issue a civil penalty to FFLs.
Yeah, that's an enforcement mechanism to make sure that material is being issued at point of purchase.
I understand what it's for. I'm asking how we're going to determine that the health department is coming up with no curriculum shown here, no advice other than that includes information regarding fire and on ammunition.
Yep.
Firearm safety, firearm training, suicide prevention.
It's not firearm training. So you keep saying firearm training.
It's on your bill.
Yeah. What I mean in the context of the training is around the mental health aspect of it with the pamphlet.
What your bill says.
Right. The mechanism
Prepared literature.
Yes.
Relating to firearms and ammunition that includes information regarding.
Yes.
1, firearm safety. 2, firearms training. 3, suicide prevention. 4, mental health awareness. And 5, conflict resolution.
Yeah. So those are the steps that they plan on enforcing to make sure that there is a pathway that when someone purchases a firearm or obtain ammunition, that there is a safety mechanism built in through that type of training.
And the encompassing part of ammunition, if you're purchasing a firearm, and by this bill, you would have already gotten this notification. So every time somebody goes to buy ammunition, we're going to go and hand them this as well. Yes. Every small box.
That's correct.
So
one of the things that we also discussed in reference to distribution, there was some talk about like a QR code, for example, as well. So that was one of the things. It may not be reflected in that was part of our testimony of kind of some of the ways that you can implement it in addition to the pamphlet itself. That was some of the statements that was made at the time.
Is that an amendment or something? Because I don't see anything that would provide for that. I just see where it says shall distribute, each county health department shall distribute the literature. That would tell me that it's like something hard copy, right? Physical.
Right.
I mean, because if you're talking about a QR code where somebody goes, oh yeah, you might want to scan that, that's totally different than somebody who's coming in. I guess what I'm trying to figure out here is what is the overall, this seems really unconstitutional. It seems like you're forcing opinions from people on people that are otherwise qualified adults to purchase a legally owned firearm.
Well, Senator, I appreciate that, and I'm pretty sure that before this committee, you hear multiple testimony when it comes to what happens when bad actors with weapons and what can happen as a sense of safety. So this is about safety. This is about what we can do as a government to offer resources to firearm purchasers to give them some mechanisms to make sure that they're making the right decisions when having these things in their personal possession.
Well, this is for any firearm. So like we already require people to be able to even, you can, you know, it's interesting to me. So there's a senator here in our body who is a concealed carry holder, concealed carry, but he can't go buy a handgun. This body, I point that out because this body makes really silly rules because he hasn't finished a lower threshold of the handgun qualification licensing in addition to his concealed carry, so he can carry a handgun legally. He just can't buy one.
Sure, Senator, and I'm pretty sure that's a different bill at some point, but I'm here specifically about the literature.
Yeah, and I'm here to point out that we have these constant ongoing attacks, new measures against law-abiding, legally lawful owning firearms people across the state, men and women, and who go out and they shoot competition. They may go out and shoot for sport. They may go out and hunt. I mean, heck, we've got a bill right now. They don't want you to use lead because apparently we're just spoiling the Earth's resources by putting lead.
Sure.
Ammo. I mean, that's a lot of lead.
I agree, and I'm pretty sure every day that you have to make decisions on behalf of all Marylanders in the best interest of those Marylanders. This is what this legislation is about, us making the best decision on the best interest of all Marylanders, and that's where we are.
I appreciate that. So I'm going to finish with this then. What qualifications does the Maryland Department of Health have to create literature around firearm safety and firearms training?
Sure. I'm pretty sure within the Maryland Health Department that their responsibility is health care, mental health, things that may be related to the crisis of someone that may have a weapon and how they may use it during that crisis. And this is a preventative tactic, that measure that we're attempting to take here with this legislation.
So again, I'm going to add, so I don't hear an answer. There's no one qualified in the Maryland Department of Health surrounding firearm safety and firearms training. So, and I don't see any discussion in here about the Maryland State Police to come up with an additional dialogue or mechanism.
Sure. So I'm pretty sure you understand that Maryland State Health Department is one of many state agencies in collaboration. So I'm pretty sure they have the mechanism to not only work with our state police and other law enforcement agencies, but also our universities when it comes to research and development to make sure that we're doing our part to engage.
But that, Delegate, that's not what this bill says. This bill doesn't say to form a work group with collaborative partners across the state.
I'm saying that it's a collaboration at all times.
Hold on, Delegate.
Sure.
It doesn't say we're going to establish a work group.
Nope.
To study this issue, this very important issue, and come up with this literature targeted specifically at these things. This says that the Maryland Department of Health shall, that's a mandate, prepare literature relating to the firearms and ammunition. And so the ammunition is such a broad scale of different types of ammunition, you know, hollow point, ball, boat tail, you know, all these different things. Are we going to, is it just going to be a general oversight? There's no guidance in here. So this is, my point is this is very broad. This is not seeking any collaboration from partners, but this is requiring a mandate on the health department to come up with said literature. It doesn't mention anything about a QR code. It is a requirement that literature be in the store, handed out at every purchase. And this is, and there's nothing founded on factual data that would be a measurable standard of them. So that's my concerns, and I appreciate the bill. Thank you, Dell.
Thank you both. Senator Muse and then Senator West.
Just one question. Thank you for the bill.
Thank you.
I bought maybe 4 or 5 guns in my time, and I always have to go through a training of 6, 8 hours. What's the difference between that and handing out another pamphlet that says it's pretty much the same thing? That's number one. Number two, why can't you just include that in the training that we already have? And this is about the first time that I've agreed with half of what my seatmate has said. Wow, boom.
Sure, Senator. So one of the things when it comes to nomenclature of firearm training, that these are a lot of times conducted by private vendors. This is a governmental requirement to the purchaser and the seller at point of sale to make sure there is something, there's nothing that once that weapon leaves the store that can guarantee that this will take place. So this is a way of making sure that we have the literature in hand to have them, that they can make an informed decision based on the information that's provided in the literature at the time.
Okay, thank you very much. And so now when I come before your committee, y'all better treat me nice.
I don't know, y'all had me here all day.
I'll tell you what I'll do. I will take your bill and shoot it up.
I appreciate it. Happy Maryland Days.
Thank you.
All right, Senator West and then Senator James.
Thank you, Mr. Chair. So the relevant Supreme Court decision in this case dealing with the constitutionality is the Zauberer case, spelled Zauderer, Z-A-U-D-E-R-E-R. And what it establishes is that speech may be compelled if the literature is purely factual and uncontroversial. That's the standard, Supreme Court standard.
Yes.
So would you have a problem in amending your bill to modify the language on page 2, line 10, where it says the Maryland Department of Health shall add the words purely factual and uncontroversial before the word literature? So it would read, the Maryland Department of Health shall prepare purely factual and uncontroversial literature relating, et cetera, et cetera. Is that a problem?
It's not a problem for me, Senator. I
think that would make the bill pollucidly constitutional. And
outstanding.
It would tell the Department of Health that they need to be very careful to make sure that this literature, however it reads, is purely factual and uncontroversial.
Okay. Yes, sir.
Thank you for your answer to my question.
Yeah.
Thank you, Senator James.
Thank you.
And then Senator McCain.
Good to see you, Delegate.
Yes, ma'am.
I read the fiscal note, and because I don't know if you sit on your version of judicial proceedings or not, but in here, do you? So I look at the fiscal note, and I know that since I've been here and I'm a newer senator, we have passed a number of bills, and it's come up in discussion. We have this very, very credible handgun qualification license and we have incredible trainers that give lots and lots of instruction. And when I looked at the fiscal note, the instructions they're going to give is everything that's in your bill. So we already have a group that's doing that, and it's approved. And the state police weigh in on this. Lots of other experts around the state do. I don't know if the health department is or is not included, but they're certainly not the lead, and they're not sole. And it's very collaborative from the get-go, and it already pre-exists. And then there's the Center for Firearm Violence Prevention and Intervention, which we created recently, really recently. And again, we're asking a lot of collaboration to deal with many aspects that are of safety and so on. To me, the problem with your bill, and you can respond, is that I would have drafted a bill that tasked one or both of these entities or use the existing structure. And yes, the handgun qualification license are by trainers, and of course, but they're vetted through quite an elaborate system we already have. I would have borrowed and utilized that existing system to create something that is in writing. I would have made sure all that writing was not inconsistent in any way with the training already given, because that would certainly be counterproductive, confusing, and probably not lawful. And then worked with that. So I'm a little confused about why you didn't work off of the hard work and deliberation that's already been done, that's already training people about these issues when you buy a gun. And then what you're suggesting is, well, listen, even if they don't have to have the training, but I think everybody does. I'm gonna have to ask somebody, if they buy a gun, they'll get this. So it just seems to me there's a real disconnect, and the opportunity for there to be inconsistency is huge. So what's your thought about trying to amend the bill to make it work off of what we've already done in this area?
Sure, thank you for the question, Senator. So obviously, the intent behind the bill is about establishing a pathway to relate pertinent information at point of sale through presenting this literature that will be designed by the health department, state health department, utilizing their resources to formulate that literature and disseminate it at point of sale.
Well, but we already have the Governor's Office of Crime Prevention and Policy, and we have the Maryland State Police. We have lots of people that are broader than the health department. And I bet the health department, at least I hope they have some humility, would say, even if you task us with this, we could not possibly do this solely, because we would not be qualified unless we partnered with what already exists, which is why these bills and these laws were passed with such deliberation. I don't think we would have ever created a gun bill and asked the health department to be the sole leader in it. I don't think we ever haven't been here long enough. So anyway, I think that may be an area you want to consider. Thank you very much.
Thank you, Senator.
Thank you, Senator McKay.
Chair, thank you, Delegate, for bringing the bill. As I understand, this bill shifts the role of public health messaging into private businesses by mandating the distribution of state-authorized literature at a point of sale. And of course, then it's also backed by fines and inspections. So my question has to do with, do we do this already in the health department? Do we already take private businesses and mandate that they have to have public health messaging distributed?
To my knowledge, the health department does have guidelines around distributing information dealing with businesses. I believe a lot of it, one of the examples I would say is around food distribution and safety around food. To the penalties aspect of it, I cannot tell you.
Okay.
I do not know.
Right, but I guess my thing is that to me, it's one thing for, I don't know, in the examples that you gave,
sure,
that there are actually where they're mandating the distribution of it. There's one thing for education around said, but I don't know that. The other thing has to do with the other senators brought off that there's already training that is required for them to at least get the license to then be able to purchase the firearm. But my question has to do with, are you familiar with Supreme Court decision Advocates versus Beccaria, where the Supreme Court made it clear that government may not compel private parties to deliver a message absent to a compelling justification? And since we're already doing this in the training, I don't know where your compelling justification would be. And so I don't see one as it relates to that Supreme Court decision.
Sure. To that Supreme Court decision, I'm not aware of the outcome. I will tell you that I indicated in my opening statement that this was challenged before the U.S. Supreme Court, and they took no position on it, and it was returned back to the county and to the state in reference to this legislation. So to that avail of what you just mentioned, I am not familiar with.
Okay, it's in the committee testimony. You might want to check with this. Happens to be a gentleman, Thomas Cabasa, but anyhow.
Okay.
Go ahead and check that out and maybe be able to get back with us and where that applies. My whole thing is, we've acknowledged that we already have trainers that train people to do this. They have to go through the licensing process, through the training. And since that Supreme Court justice decision said that you had to justify a compelling justification for it, I'm not exactly sure that the training, which is already there, to then get the purchase, that you're presenting with this bill that it is a justified justification. So might want to square that up. Thank you, sir.
Great.
Thank you.
Thank you. All right, seeing no further questions, thank you, Delegate. Thank you, Mr. Bellamy. We'll now move to the opponents of the bill. Mr. Pennock from District 18.
Thank you, Mr. Chairman. Mark Pennock, President of Maryland, shall issue rise in opposition to this bill on grounds that it's a question of constitutionality, and even if it's constitutional, it's ill-conceived and poorly thought out. So the constitutionality is discussed in that length in my written testimony. I would like to bring the committee's attention to the circuit split concerning the scope of the Zouderer doctrine on which the Fourth Circuit relied in the case in which the sponsor has cited. So there is a petition for cert presently before the Supreme Court in which that circuit split will be probably, the cert petition will be granted and we'll get a decision from this. So the Zouderer allows purely factual and uncontroversial information to be distributed about the services which will be rendered. Now, none of these services that's specified in the bill are rendered by an FFL. I'd also like to address the point that there are 785 FFLs in the state. An uncounted number of people who sell ammunition who need not be FFLs. So you're going to have localities which already have noted in the fiscal note that they don't have the manpower to do this, to actually ferret out all the mom and pop stores and the corner stores that sell ammunitions. That could be just a box of 22s. And you have many FFLs who don't have stores, who operate without that storefront. And finally, compelling commandeering FFLs, even with stores, is to invite resistance because nobody likes having the speech jammed down their throats. They will invite their customers to throw it in the trash, thereby being completely counterproductive. I urge an unfavorable report. I'm happy to take questions.
Senator Folden.
Thank you. Thanks for coming, Mr. Pennock. Good to see you. When I'm looking back through here again, I want to go back to my point of, are you familiar with any firearm safety or firearms training that would be possessed by the Department of Health to be able to be subject matter experts to hand out factual information?
It's an excellent point, and no, the Department of Health doesn't know anything about it. I'm a trainer. I teach this subject. State police imposes a curriculum on me. They know something about the subject, but the Department of Health certainly does not.
Right. And then it also talks about, it's pretty general. It says establishments that sell firearms or ammunition within the county. I mean, that could be even broader than just FFLs.
Oh, it most certainly is. It includes all the mom and pop stores that sell ammunition.
Just
It's a corner store.
Like there's a little Heim store, a little country store up in Washington County.
Exactly.
And they sell ammunition on the shelf. They don't sell firearms.
That's right.
But they sell ammunition because they're a local little
And
vendor.
that's not regulated, by the way. So
Correct.
there's no way of identifying them through some database, who sells ammunition, who doesn't.
And then it doesn't say anything about, I don't know, if you transfer like a rifle that's not required to be.
Oh, a private sale? Mm-hmm. That's correct. So that does not appear to regulate that, although it's not altogether clear exactly whether that would be covered or not under the language of the bill.
And then if we take the 785 FFLs that you mentioned, not to mention the mom and pop stores that sell ammo, it talks about that they're required to distribute this literature. It doesn't talk about anything about replacing the literature. And I mean, is that then left upon the owners of that facility to do it on their own?
Well, the way the bill is structured is that the State Department of Health is going to print it up and then distribute it to county departments of health who are then required to distribute it. So it's not altogether clear what happens if the county falls apart and doesn't do that job.
Right.
Or if they run out of the literature, or whether or not that means they can't sell it. So it seems to me that the implication of the bill is that you may not sell ammunition or firearms without distributing this information, which you may not have in your possession, which may mean that you have to shut down.
Well, correct, by this bill. And then I guess that was my other part, is I see that it says a person who violates this section has 2 penalties. It doesn't give anything for like any due process or an adjudication of that, but it talks about the first violation, second violation. But my concern is that what if they're not being provided it by the county health department, being replaced in a timely manner?
Then conceivably they might be cited for failing to distribute or making a sale when they didn't provide the account information.
Well, I guess we could always put an amendment in there that there's a civil violation on the county health department for not distributing.
That would at least give them incentive. They already said in the fiscal note that they don't have the manpower to do this. So you're basically imposing an unfunded mandate on localities that's not in the cost. And the state is now incurring up to $50,000 a year to print the literature, which is more likely than not will just end up in the trash can next to the dealer's counter after he tells the purchaser, by the way, the state is making me give this to you. I think it's trash. You can throw it away if you like, and there's a can. Congratulations.
Thank you for that. And I guess my last question is I don't know that I agree with my good colleague here who likes to try to fix every bill. And as putting a way of purely factual and uncontroversial, like a disclaimer in this bill, because just even by putting it in there that you're saying, oh, this is purely factual, and it really comes down to what they put into the.
Absolutely.
And that leaves, even by adding that in the bill, it still leaves it up to the discretion of the health department to put in what they may objectively believe is not controversial or purely factual, but may be totally wrong because they're not subject matter experts.
I've litigated this, and you can be sure that what I view as purely factual and uncontroversial is probably going to be substantially different than how the Department of Health views it.
That's what I figured as well. Okay, thank you for your testimony today.
Further questions for Mr. Pennock? All right, seeing no questions, thank you, Mr. Pennock. That concludes the hearing for House Bill 875. I think we have a representative from Delegate Williams' office, her Chief of Staff, so please come up for House Bill 1152.
All right, thank you, Chair Waldstreicher, members of the Senate Judicial Proceedings Committee. I'm Michael Marino. I work for Delegate Nicole Williams, and I will be testifying in favor of House Bill 1152, also known as Department of State Police Special Police Officers Study. This legislation will require the Department of State Police to conduct a study regarding the employment and use of special police officers. The findings and recommendations of this report would be due to the Governor and the General Assembly on or before December 1st, 2026. Special police officers serve a variety of roles throughout the state of Maryland, with their authority and responsibility dependent on their jurisdiction or employer. This legislation seeks to provide a data-driven and evidence-based approach to identifying challenges, highlighting best practices, and developing balanced recommendations towards enhancing the role of SPOs. In doing so, this legislation will seek input from a variety of stakeholders, including SPOs, their employers, police chiefs, sheriffs, prosecutors, and other impacted officials. Such a collaboration offers an excellent opportunity to provide a thorough and detailed report on SPOs to the Governor and the Maryland General Assembly. For these reasons, I urge this committee to give a favorable report on House Bill 1152. And I'd also like to note that I have Ms. Catherine Keller here from the Maryland State Police to answer any questions if needed.
Wonderful, thank you. Any questions regarding House Bill 1152? Senator Folden. So these are sponsor only. If you want to do a quick.
No, it's okay. No, I just wanted to see how pained she was when she saw my name, ask her to come up. So I appreciate you being here today. Thank you. And you guys are obviously in support of Yes, okay, thank you.
Thank you for the brevity. Any other questions regarding this bill? All right, seeing no further. Oh, I'm sorry, I didn't see you, Senator Sidnor. Please.
What's the impetus of the bill?
I'm sorry?
Why is the bill being presented?
Thank you for the question, sir. For the record, Catherine Kelly, Maryland State Police Government Affairs. Last year, there was an expansion, for lack of a better word, for SBOs to be employed by security guard agencies. When we were looking at the program, there are a lot of elements that need to be perfected. The application process, making sure that the parameters in public safety are very, very clear, because there's more and more SBOs that are getting licensed every year. So we just want to make sure that the whole process is looked at, refined if necessary, to make sure public safety is number one and we don't have any issues that will be negative.
So this isn't looking at things like the Johns Hopkins Police Department or the police department that was created on the Eastern Shore. I'm trying to remember what police department that was. Ocean Pines, those types of things doesn't include.
These are just special police forces. And looking at the process, looking at any complaints that have been had for any operations outside of scope. And we have had a few over the SBOs have been in effect for quite a few years. Just making sure we can look at what needs to be refined and tightened so public safety is best served.
But not necessarily the special police departments that we created legislatively. I'm just trying to understand the scope, because off the top of my head, I don't remember how we define an SPO and whether or not.
An SPO typically is a commissioned police officer that works for an owner of a property.
So would that include Johns Hopkins Police Department? It does not. Okay, that's all I'm trying to figure. Thank you.
Good questions. All right, anything further? Thank you so much. That concludes the hearing for House Bill 1152. That also concludes our hearings for today.